much regarding your officer, but tell him to be serious in court.
Absolutely.
You're not his peon sitting over here with subnormal IQ that he will think that he can come and throw wool over our eyes.
Yeah, absolutely not.
They need to be careful in court. Because we can, with one stroke of pen, finish him off and his career.
I'll definitely.
Yes.
Lordship, please.
May I please, Lordship?
Yes.
Lordship, I am appearing on behalf of the petitioner.
Yes.
Lordship, actually, the documents and information for which we had filed the RTI, the petitioner could provide us only yesterday evening. So, Lordship, may come to allow us 2 weeks' time to file the rejoinder affidavit.
Who are you appearing for?
I am appearing on behalf of the petitioner, Lordship.
You're for the petitioner.
Yes, Lordship.
Since the petitioner seeks some time to put fresh material on record, let the matter stand over for 2 weeks. Mr. Khan, what is
Much obliged.
Lordship, he's coming 5th. Matter is listed on 6th. The Lordship is coming. The full bench matter is listed on 6th.
Yes.
He's coming.
Item number 3.
May I please ask your Lordships? The affidavit in reply will be filed today during the course of the day, Your Lordship.
What's the matter about, sir?
Lordship, it's a matter about order in original past time board, Your
Very
Lordship.
good.
Time board order.
You're the petitioner.
Yes, Your Lordship.
You filed the affidavit in reply.
During the course of the day, today, Your Lordship.
Since the petitioner seeks a further day's time to file the affidavit in reply, let the matter stand over for a week.
May
The affidavit in reply should be filed in the course of this week.
I have small prayer also, Your Lordship. Kindly the matter may be taken after to any date after 25 of July for final hearing, Your Lordships.
Let us come next week.
Published.
Item number 4.
Your Lordship, I am appearing on behalf of the petitioner, Your Lordship.
Yes, what is the matter about?
Your Lordship, we have challenged the order, we have challenged the inaction of the respondents in refunding the Siemens
Yes.
as per order dated 9th February of 2022.
Were
Your
you
Lordship,
one
we have
of
yet to
the petitioners?
Yes, Your Lordship.
You were one of the petitioners. You were one of the petitioners, Mr. Khan is required.
No, he was not one of the petitioners.
You were not one of the petitioners.
We are not.
No.
We are not one of the petitioners.
If you are not one of the petitioners, you have no right.
Lordship has already decided
The
that.
matter has been decided in another matter. Only the petitioners, people sitting on the fence, have no right. Let's finish up the matter.
Lordship,
No.
in
Last judgment.
Lordship is on
Because the order was very specific. It gave some 20% or 15% something for the petitioners by way of cost for having fought the matter. But those who had not filed were not entitled to that. And we subsequently held that.
This was held, Your Lordship, in WPC 180.
This petition has been filed. Now, the petitioner here claims to have been adversely affected by the imposition of illegal cess on cement by the state. Full stop. Indeed, this petition is based on a judgment and order of this court of February 9, 2022, passed in WPC number 280 of 2016, bracket, Mega Technical and Engineers Private Limited versus State of Meghalaya, by which the cess imposed by the Meghalaya Cement Cess Act 2010 was found to be illegal and without authority. Full stop. The relevant order of February 9, 2022 provided as follows in paragraphs 15 and 16 thereof. Colon, set out paragraphs 16 and 15 and 16. The order was clear and unequivocal that the refund of 20% that was directed to be made by such order was to be made to the individual petitioners out of the amount seized from them. Full stop. The refund was confined to the petitioners who had challenged the imposition of the cess and was not for other manufacturers who had not challenged the impost. In any event, manufacturers, who had passed on the levy to the end users, who did not have had a claim for refund, semicolon, but the token refund of 20% was awarded by the relevant order of February 9, 2022 by way of costs that may have been incurred by the petitioning manufacturers who had assailed the imposition of the cess. Full stop. Paragraph. A similar petition as the present one came to be decided on June 16, 2023 in WPC number 180 of 2023 bracket Hill Cement Company Limited versus State of Meghalaya bracket closed. Such order of June 16, 2023 clearly recorded as follows at paragraph 6 thereof. Colon, set out paragraph 6, paragraph for the reasons indicated above. And since this petitioner was not entitled to any benefit under the order of February 9, 2022, WPC number 84 of 2023 is dismissed. There will, however, be no order to us. Yes.
Item number 5.
Today we are looking at an appeal for an offence under 302. Well, a brief facts of the case is, my lord, two people were found to be drunk, and my lord, a murder took place nearby. So the suspicion was made in the mind of the village defence party that perhaps these people were involved in the crime. Well, they were taken to the community hall, kept there the whole night. The police was informed next morning. Next morning they were arrested, taken to the excuse me. Taken before the magistrate on the same day with a prayer to record confessional statement. Now, my lord, the magistrate sent them to judicial custody and the confessional statement was recorded the very next day. The entire case revolves only on the basis of conviction has been arrived at only on the basis of confessional statement. Well, there is no strong corroboration. Even circumstantial evidence also will not directly point to the guilt of the accused persons. Here, two accused have made a confessional statement stating that I have killed him. Appellant 1 says that I was the one who struck him on the head with a wooden stick and I killed him. Appellant 2 also says the same thing. Now, apart from that, well, there is nothing else. These people were only given half an hour's time. Joint appeal, my lord. Well, joint reason because, my lord, nobody has made any allegation against the other.
No, but their confession says who killed?
I say I killed, the other says I killed.
So therefore, that's contradiction.
So, well, in a similar case, Lordship, in fact, had asked, so perhaps, my lord,
You'll probably have the difficulty.
So, I may allow to do the.
Said that he did, I did, and he did. All right.
Here, both of them say that I did.
I know.
So, my lord, in a similar case, my lord, I was observing it to VC. My lord, I will do that, Lordship.
leave is given to the appellants to withdraw the present appeal and to file afresh and to file individual appeals, since the joint stand may be compromised since the joint stand may not be beneficial to their individual interests. Paragraph, in the event such independent appeals are filed within 3 weeks from date, the prayer for condonation of delay may be leniently looked into. We can't control
My
it.
Lordship. Margin.
From the main list, item number 1.
Lord, here I appear for respondent number 6 on behalf of Mr. Paul Marut. Yesterday we received a affidavit filed by the petitioner. Just yesterday, my lord, can you grant us some time?
Sixth respondent.
6 respondent.
Since the sixth respondent says that a recent affidavit has been received from the petitioner only on June 3, 2023, let the matter stand over for 10 days,
No.
full stop. If any rejoinder is to be used by any of the respondents to the latest affidavit by the petitioner, such rejoinder should be filed in course of this week.
Deeply acknowledged.
Deeply.
Item number 2.
Lordship, this was regarding Section 11 of the Arbitration
Yes.
Act.
Have we agreed to the
Lordship,
arbitration?
we have agreed to it. He's from Guwahati, Honorable Justice C.R. Sharma.
Can we have some writing?
Lord,
At least counsel sign it.
huh. Can you say it? Can you say it?
Counsel on either side should sign it, and then
I can't say it.
that would be sufficient compliance with Section 7.
Absolutely.
You are the advocate on record?
Lordship, yes.
He is the advocate on record?
Lordship, yes.
Very good. And you are the advocate on record, madam?
Yes.
Very good. Always put your date after your signature.
Lordship, yes. Absolutely.
You are in the legal profession.
Need full name in some place.
Give it.
One would
Only
do.
one. No. Let us sign.
This request under Section 11 of the Arbitration and Conciliation Act 1996 was adjourned on June 21, 2023 upon a recording the fact that the parties indicated that they may consent to an arbitrator based in Guwahati or Shillong to take up the reference. Full stop. Paragraph. The parties now suggest that Justice, what is his name?
Justice C.R. Sharma.
C.R. Sharma, bracket retired, be appointed to take up the reference and all disputes covered by the arbitration agreement between the parties. Full stop. A document with the name of Justice C.R. Sharma, bracket retired, ticked therein, has been handed over to court, signed today by advocates on record on either side. By advocate on record on either side. Full stop. Paragraph. Accordingly, comma, the petition is disposed of by requesting Justice C.R. Sarma, S-A-R-M-A, to take up the reference in accordance with the arbitration agreement between the parties. Paragraph. Petition number 2 of 2023 is allowed as above. There will be no orders to cause.
Obliged.
Obliged.